Picture this scenario. It is a Tuesday morning. You have resided in your house for 31 years. You brought up your kids here. You cleared your mortgage entirely. You handled everything correctly. And then an envelope shows up. It states the county has attached a lien to your property. Not because you committed any offense, but because of one document you never realized you were supposed to submit. And now your family could forfeit the residence you spent a lifetime constructing. If you are above 60 and you own your residence, the following 10 minutes could safeguard everything you have labored for. Today, we are going to walk through 5 documents that property owners above 60 absolutely need to submit. These are not complex. They are not costly. But if you neglect even one of them, the IRS, Medicaid, or your county administration could have a lawful claim against your residence. Now, I need you to remain with me until document number 3. Because that is the one the majority of people overlook completely, and it is the one that silently wrecks family inheritances every single year. Let us begin. I want to share with you about Robert. Robert is 68 years old. He resides in Ohio. He possessed his residence for 27 years. Robert was intelligent. He had a will. He maintained a savings account. He even carried a Medicare supplement policy. He assumed he was set. Then 2 years back, Robert suffered a stroke. He pulled through. But he required 3 months of nursing facility treatment. His daughter, Patricia, attempted to manage his finances during his recovery. She contacted the IRS regarding a tax refund Robert was owed. The IRS responded, "We are unable to communicate with you. You lack authorization." Patricia possessed Robert's standard power of attorney paperwork, but the IRS demands a very particular form, Form 2848, or a durable power of attorney drafted to satisfy IRS criteria. Robert's paperwork did not meet the requirements. The refund remained locked for 7 months. Then the nursing facility charges arrived, and here is where the situation deteriorated further. 3 years prior, Robert's neighbor had advised him, simply transfer your residence into your daughter's name. That way, Medicaid cannot access it. Robert followed that advice precisely. What Robert was unaware of was this. Medicaid enforces a 5-year look-back provision. Because Robert conveyed his residence within that 5-year time frame, he was refused Medicaid coverage for his nursing facility stay. The charges exceeded $14,000 from his own funds. Robert forfeited money he could never recoup. Not because he was negligent, because nobody explained to him which documents to submit and in what sequence. Today, I am going to guarantee that does not occur to you. Document number 1, IRS Schedule 1A, the $6,000 senior deduction. This one is completely new, and the vast majority of seniors are completely unaware it exists. Under a recent statute called the One Big Beautiful Bill, active right now for tax years 2025 through 2028. If you are 65 or above, you are eligible for an additional $6,000 tax deduction per individual. That means if you and your partner are both 65 or above, that is $12,000 removed from your taxable earnings. This is independent from your standard deduction. It functions even if you do not itemize. But here is the essential detail. The IRS will not grant you this automatically. You must submit Schedule 1A alongside your Form 1040, and it reduces gradually if your earnings exceed $75,000 or $150,000 for married couples. If you fail to submit this for 2025, speak with your tax preparer right away. You may be able to submit an amended filing. Here is something that startles most seniors. Your property tax reduction for being above 65, it does not activate automatically. You need to request it. And in the majority of states, if you miss the cutoff date, you forfeit that complete year of savings. In Texas, for instance, property owners 65 and above receive an extra $60,000 reduction on school district assessments. Your school tax figure becomes locked. It cannot increase as long as you occupy that residence. But you must submit Form 5114 to your county appraisal office. and you must submit it within 1 year of reaching 65. Other states maintain comparable programs. Florida, New York, Arizona, South Carolina, New Jersey, they all provide senior homestead safeguards, but every single one demands a separate request form. Navigate to your county's appraisal or tax assessor website today and look up senior homestead exemption. The savings can range from hundreds to thousands of dollars annually. This is the document practically nobody mentions, and it could be the most significant one on this entire list. It is referred to as a transfer on death deed, or TOD. Here is how it functions. You complete a straightforward form. You designate the individual who will inherit your residence when you pass away. You have it notarized. You register it with your county recorder of deeds. That is all. When you pass, your residence conveys directly to that individual. No probate, no attorneys, no courtroom, no waiting periods. And here is the crucial detail. You maintain complete authority over your residence while you are living. You can sell it, refinance it, or revoke the deed whenever you choose. Without this document, your residence enters probate court. That procedure can consume 6 to 18 months. It can cost your family thousands of dollars in attorney charges. And if multiple relatives have any dispute, the court determines who receives your residence. AP identifies this as a tangled title circumstance, and it occurs every single day to families who believed they were safeguarded because they possessed a will. A will still proceeds through probate. A transfer on death deed does not. At present, more than 30 states permit TODs. Verify with your county recorder's office or your state's official website to determine if your state permits it. Recall Robert from our account? This is the document he was lacking. A durable power of attorney composed to IRS criteria permits someone you trust to manage your financial and tax affairs if you become incapacitated. And the essential term here is durable. A standard power of attorney turns invalid the instant you are incapacitated. A durable power of attorney continues in force. That is what distinguishes it. But here is what the majority of people are unaware of. For IRS affairs, your durable POA must satisfy the particular requirements of IRS Form 2848. If it does not, the IRS will deny your representative, even if you are hospitalized, even if you are unable to advocate for yourself. Consult with an estate planning attorney and specify to them directly, I require a durable power of attorney that is compatible with IRS Form 2848 specifications. This shields you from locked refunds, unaddressed audits, and penalties that accumulate while you are unable to act. Document number 5, Medicaid Asset Protection Submission. This is the one that can cost seniors the greatest amount of money if they fail to prepare sufficiently early. Here is the regulation. Medicaid maintains a 5-year look-back duration for long-term treatment. That signifies if you convey your residence, gift it to your children, or dispose of it for below market value. Within 5 years of requesting Medicaid nursing facility coverage, Medicaid will impose a sanction. They will postpone your coverage, and you will need to cover the nursing facility charges yourself. The typical nursing facility in America costs above $8,000 per month. That sanction duration could translate to tens of thousands of dollars from your personal resources. Here is what genuinely shields you. A correctly scheduled life estate deed submitted more than 60 months before you require nursing facility treatment can protect your residents from Medicaid recovery. And when your beneficiary inherits the property, they obtain a stepped-up cost basis, meaning if they dispose of the residence afterward, their capital gains tax is significantly diminished. But the scheduling is everything. The countdown begins the day you submit it. If you are above 60, the moment to prepare is now, not when you require treatment. All right, let us make this straightforward. Here are your 3 actions. Record these. Step 1. Submit or amend your tax filing for the senior deduction. Visit irs.gov and look up Enhanced Deduction for Seniors. If you completed your 2025 taxes and did not claim the $6,000 deduction on Schedule 1A, contact your tax preparer this week. You may be able to submit an amended filing and retrieve that money. Do not abandon $6,000 or $12,000 uncollected. Step 2. Contact your county and submit your homestead exemption and TOD. Contact your county tax assessor's office and pose 2 inquiries. Am I presently receiving my senior homestead exemption? Does my state permit a transfer on death deed? And what is the process to submit one? Both of these can be accomplished rapidly. Both can spare your family tremendous expense and hardship. The TOD costs very little to arrange, and it can spare your family months of legal conflict. Step 3. Obtain the proper legal documents, durable POA, and Medicaid strategy. Arrange one meeting with an estate planning attorney. Inform them you require 3 items. 1. A durable power of attorney that satisfies IRS Form 2848 specifications. 2. An examination of your property deeds for Medicaid look-back vulnerability. 3. A life estate deed or transfer on death deed. Whichever your state authorizes, 1 meeting, 1 afternoon, it could safeguard your residence, your savings, and your family's future. Now, before wrapping up, there is something significant to mention. Platform notifications are not dependable. Critical regulation changes, new IRS cutoff dates, Medicaid policy revisions, Social Security notifications, they do not always reach you promptly through online platforms. When you join, you will receive instant access to a complimentary Senior Benefits Protection Guide, a step-by-step document that guides you through every form, every cutoff date, and every government office you should be aware of. And you will obtain real-time notifications whenever there is a new regulation affecting your Social Security, your Medicare, your pension, your bank accounts, your insurance, or your residence. Click the link in the description right now. It requires 10 seconds and it could spare you thousands. If this video assisted you today, please forward it to one individual you care about who is above 60 and possesses a residence. They may be unaware of document number 3, and you could be the reason their family does not forfeit everything. Take care of yourself and safeguard what you have constructed. I will see you in the following one.